Okay, let's dive deep into a story that, honestly, it feels like something straight out of a legal thriller.
Mm.
But this wasn't fiction. It played out in the very real, often very formal world of Sydney barristers.
Yeah, you picture those, quiet, intense courtrooms, the wood-paneled chambers.
Right, where reputation, integrity, that's basically currency.
It's everything. And sometimes, even in those places, a really dark cautionary tale emerges.
It does happen.
It really does. The legal profession, it demands an incredibly high standard of conduct. Not just in court, but like in everything a lawyer does.
Mm-hmm.
And when that standard is breached, especially through dishonesty, well, the system has to react decisively.
Why so strongly?
It's fundamentally about protecting public trust. You know, that trust is the bedrock of the justice system. If people don't trust lawyers, the whole thing falters.
And that brings us right to the focus of this deep dive.
Yeah.
The case of Marcel Victor Sahade.
The Sahade.
He was, once upon a time anyway, seen as a bit of a rising star at the bar. Maybe a little unconventional.
A bit outside the typical mold, yeah.
So our mission today, using this pretty hefty stack of sources you've shared, court judgments, articles, research notes, is to really unpack this specific legal drama.
Right.
We want to understand exactly what happened, who all the players were, and crucially, why this case became such a significant, almost legendary cautionary tale, particularly for anyone thinking about becoming a barrister.
It's got all the elements, really. Ambition, definitely, deception, and a near-total catastrophe for a legal career.
So Sahade, he was admitted to the NSW Bar in '95, born '72, relatively young then.
Yeah. And he had this reputation among some colleagues. Words like enterprising, risk-taker, maybe even a bit of a gambler get thrown around in the sources.
And the nicknames, too.
Ah.
Our favorite punter, Shagwell, Jumbuck. Gives you a sense of the personality, maybe?
Perhaps. It suggests someone, a bit colorful, maybe someone who pushed boundaries, and not just a dry legal case, this. There's a human element of someone clever, confident. Perhaps too confident he could game the system.
And that scheme, which we'll definitely get into the details of, it almost cost him everything.
Everything.
We're talking about the ultimate penalty for a lawyer, aren't we? Being struck off the rolls.
Disbarred forever.
Yeah. And it all spun out of this plan to exploit a perceived loophole in the Australian government's Telstra 2 share offering way back in 1999.
That's right. A massive public float. Huge event. And he saw this opportunity, an opportunity for potentially massive profit.
Right.
But the way he went about it, the whole thing was built on a foundation of, dishonesty. That's the core issue.
Okay, so it's a real legal saga. And by digging into these sources, you're saying we can get a shortcut to understanding all its layers.
Yeah, hopefully. Understand the mechanics, the people, and the profound implications it had and still has for what it means to be a fit and proper person to practice law.
Okay, let's start then by meeting the cast of characters in this legal drama, the dramatis personae, if you will.
Good idea.
At the absolute center, as we've said, is Marcel Victor Sahade. We know he was admitted young, had these nicknames. What else do the sources tell us about his standing or perception before this whole thing blew up?
Well, beyond the gambler image, he was a practicing barrister. He had chambers, colleagues, peers who knew him well. And as we'll see later, quite a few of them actually stood by him.
Right, that becomes important later.
Crucial. So he wasn't some unknown figure operating in the shadows. His ambition, his drive, they were recognized qualities. But, arguably those same qualities might have contributed to the hole he dug for himself.
Okay, so Sahade is our central figure, the protagonist, if you like, whose journey we're following. Who are the other key players, the institutions caught up in this?
Well, first, the target of the scheme itself. The Australian government and Telstra, they were running that massive share float. They were the authority Sahade was trying to, deceive.
Got it. So they're the victim, in a sense. And when the scheme started to unravel, who stepped in from the regulatory side?
That's where the Australian Securities and Investments Commission, or ASIC, comes into the picture. They're the corporate watchdog.
Right.
They're systems. They're investigators. They flagged the unusual activity around the share applications. It looked suspicious.
And because it involved potentially defrauding a Commonwealth authority.
Exactly. That brought in the Commonwealth Director of Public Prosecutions, the CDPP. They're the federal prosecutors. They decided the evidence was strong enough to initiate criminal proceedings against Sahade.
So ASIC spots it, CDPP prosecutes criminally. But you mentioned this wasn't just a criminal matter. The legal profession itself got involved.
Absolutely critical point. The Council of the NSW Bar Association played a huge independent role here.
They're the governing body for barristers in New South Wales.
That's right. Their job is to uphold the standards, the ethics, the integrity of the bar. So when Sahade's conduct came to their attention, completely separate from the criminal case, they launched their own inquiry.
Into his fitness to practice.
Precisely. And ultimately, they pursued formal disciplinary action against him. They are, in effect, the guardians of the profession's own ethical code.
And these disciplinary actions, they don't happen in a regular court, do they? They go before specific bodies.
Correct. The first stop for the professional misconduct case was the Administrative Decisions Tribunal, specifically its Legal Services Division.
Okay.
This tribunal is set up specifically to hear these kinds of cases against lawyers. And the sources actually name the 3-member panel for Sahade's initial hearing.
Who were they?
It was Justice J. Nader, QC, who was the deputy president and a judicial member, S. Norton, SC, another senior barrister sitting as a judicial member, and A. O'Neill, who was a non-judicial member, bringing a lay perspective.
So a mix of legal and non-legal members.
Yeah, and this panel had the really crucial job. Hear the evidence, decide if professional misconduct actually occurred, and then importantly, decide on the penalty.
So the ADT was the main battleground for the professional case. But it didn't end there, did it? There were appeals.
No, it went higher. The case eventually ended up in the NSW Court of Appeal, which is one of the highest courts in the state.
Right.
Appeals from tribunals like the ADT, especially on significant points of law or principle, can go there. And the panel hearing Sahade's appeal was, well, it was made up of 3 very senior, very eminent justices.
Who really?
Mason Pia, that's President Mason, head of the Court of Appeal at the time, Justice Santow J.A., and Justice Baston J.A., highly respected judges. Their final judgment would carry enormous weight, set precedent.
Now, one of the really fascinating threads in this whole saga, according to the sources, is watching how the legal teams changed for both sides.
It really adds another layer, doesn't it? It shows how the strategies shifted, how the perceived stakes ramped up at each stage.
Let's track that, starting with the criminal proceedings back in May 2001. Who represented Sahade then?
The sources mention he definitely had legal representation, naturally, but the specific names aren't detailed in the judgments we have. What's clear is that his team's focus then was purely on the criminal charge.
Defending against jail time, essentially.
Right. Helping him navigate that line of admitting the facts, yes, he lodged the applications, but fiercely contesting the criminal intent, the dishonesty element needed for a conviction.
Okay, so criminal defense team. Then, fast forward to 2005, the Bar Association brings the disciplinary case before the ADT. Big shift in focus now.
Huge shift, and both sides geared up accordingly for the ADT hearing. The Bar Association, now effectively prosecuting the professional misconduct case, assembled what the sources call formidable legal teams. Experienced senior counsel leading the charge, instructed by a well-regarded law firm, Eakin McCaffrey Cox. They were clearly throwing significant resources at this. Their goal was explicit, disbarment. They weren't messing around.
And Sahade's defense in the tribunal.
Yeah.
A different team again.
Yes, a completely different team from his criminal lawyers. For this crucial professional disciplinary hearing, he retained his own senior counsel and a junior barrister, this time instructed by solicitors from Oliveri lawyers.
Okay.
And this team defended him through both stages of the ADT process. First, the hearing on liability, did he commit misconduct, and then the separate hearing on penalty.
So criminal team, then ADT team. And then it changed again for the final showdown in the Court of Appeal.
This is where it gets really interesting strategically. For the NSW Court of Appeal hearing in May 2007, both sides brought out the biggest guns they could.
Go.
The Bar Council, now the appellant trying to get the striking off order they originally wanted, brought in what one source vividly calls heavy artillery.
Who was leading for them?
Their lead counsel was P.R. Garling, SC, a very highly respected senior counsel who, incidentally, later became a judge of the Supreme Court of NSW.
Wow.
He was assisted by C.A. Webster and, again, instructed by Eakin McCaffrey Cox. Choosing such a prominent silk for the appeal really underscored how determined the bar was to overturn the tribunal's leniency.
They clearly felt the initial penalty wasn't enough. And Sahade, on the other side, trying to keep the tribunal's decision and maybe challenge some findings, did he stick with his ADT team?
No, he also changed his lead counsel for the appeal. Representing Marcel Sahade as the respondent was B.W. Raymond QC, a Queen's counsel described as a very experienced advocate. He was assisted by G. Heathcote, and instructed again by Oliveri lawyers.
And the sources make a point about Raymond QC.
Yes, the Court of Appeal judgment specifically notes that Mr. Raymond QC had not appeared for Sahade down in the tribunal hearing.
Why is that significant?
It strongly suggests a deliberate tactical decision, bringing in a fresh, very senior advocate, a QC, specifically for this high-stakes final appeal. Maybe, as the source suggests, opting for fresh eyes, perhaps a different, maybe more appellate-focused approach to defend the win he'd secured on penalty, or even push back harder on the misconduct findings.
So you see this clear escalation. Criminal defense focusing on intent, then a dedicated disciplinary team for the fact-finding tribunal, and finally bringing in top-tier senior counsel and QCs for that ultimate appeal battle.
Absolutely. It mirrors the escalating stakes. His entire career and what the bar saw as its fundamental standards were well and truly on the line by that point.
Okay, so those are our players. Sahade, the man at the center, the government and Telstra, the target, ASIC and the CDPP, the regulators and prosecutors, the Bar Association, the ethical watchdog, the ADT and the Court of Appeal, the judicial bodies, and these shifting legal teams navigating each complex stage.
A full house for a legal drama.
Definitely. Now, let's rewind back to 1999. Let's get into the scheme itself. The thing that started this whole avalanche, it began with the Telstra 2 share float. What exactly was that?
Right, Telstra 2, this was the second tranche of shares the Australian government was selling off in Telstra, the big telecommunications company it was privatizing. These floats were massive public events.
Designed to get ordinary Australians investing.
Exactly, and to encourage that, they often came with specific incentives or sweeteners.
And the sources say Sahade really zoomed in on one particular incentive here.
He did. The absolute key was a promise from the government. If you pre-registered your interest in buying shares, you were guaranteed an allocation of 400 shares. Critically, this guarantee applied even if the float ended up being massively oversubscribed, which everyone expected it would be.
So just for putting your hand up early, you got a guaranteed parcel of potentially very valuable shares.
Precisely. It was a huge draw, a guaranteed slice of a hot stock.
Sounds too good to be true, or at least too good to get lots of. Because there was a catch, wasn't there? A rule designed to stop exactly what Sahade tried.
There was. The offer documents, the terms and conditions were very clear. They explicitly stated that multiple applications by the same person were forbidden.
Forbidden. Pretty clear language.
You'd think so. And the government specifically reserved the right to just reject any applications that didn't follow this rule. That was the line in the sand.
And this is where Sahade's,
Yeah.
let's call it his creative interpretation, or maybe his audacious plan comes in.
Yeah.
What did he actually do?
Okay, so over a very short, intense period, the sources say a frantic few weeks in July, August 1999, Sahade didn't just put in one application like everyone else, or even two or three. He lodged, wait for it, 353 pre-registration applications.
353. How did he even attempt to get around the same person rule?
By using, and this is the crucial bit, slight variations of names and addresses. The sources basically describe it as creating 353 fake personas on paper.
We're not talking about just like adding a middle initial or fixing a typo. This was more deliberate.
It seems so. The judgments don't spell out exactly how slight the variations were, but the point is he used different combinations of names and addresses, and critically, he set it up so he would receive the mail sent to all these varied addresses, maybe P.O. boxes, maybe addresses he controlled somehow.
So it's calculated, designed to make these 353 pre-registrations look like they came from hundreds of different individuals.
That was clearly the intent. It wasn't random.
And pre-registering was just step one. Then he had to actually apply for the shares, right?
Yeah.
And put up the money.
Exactly. Following up on those successful pre-registrations, he then submitted 215 separate share applications.
215 actual applications.
Such one requiring a personal check from him for $1,800.
Okay, do the math. 215 times $1,800.
A massive $387,000. Nearly $400,000 of his own money poured into the scheme via those checks.
Wow, a huge personal financial commitment. What was the prize he was chasing for that kind of outlay?
The goal was simple: volume. He wanted to guarantee himself a huge allocation of Telstra shares that no ordinary investor, limited to just one application and maybe getting scaled back in the rush, could possibly get.
So 215 applications, each guaranteed 400 shares.
That's 86,000 Telstra shares he stood to acquire. 86,000. If the share price popped after listing, which everyone hoped it would, he was looking at a very substantial profit. It was undeniably, as the sources say, a bold ploy for profit.
Bold, definitely. But putting aside the potential financial gain for a second, the fundamental problem, the thing that would land him in all this trouble, was the method, the deception.
Absolutely. From any ethical standpoint, and certainly as the courts later found in no uncertain terms, the entire plan was built on dishonesty.
The court judgments used strong language, didn't they?
Very strong. Phrases like manifestly deceptive and dishonest, and its very motivation was to deceive. The court saw this not as some clever finding of a loophole, but as a deliberate, calculated effort to mislead the share allocation process using false identities purely to gain an unfair advantage.
And just to be clear, this wasn't something he was doing in his capacity as a barrister.
Yeah.
Not for a client.
No, absolutely not. This was entirely a personal investment venture, conducted knowingly, yes, but completely outside the scope of his day-to-day legal practice.
And this is the crux of the cautionary tale.
Exactly. Undertaking the scheme, this private gamble for personal gain, would very soon jeopardize everything he had built within the law. His private actions were about to have very public, very professional consequences.
Okay, so he puts in these hundreds of applications, writes checks for nearly $400,000, sits back and waits for his massive share allocation and potential profit. But a scheme this big, this complex, it seems unlikely it would just slide under the radar.
It didn't. The cracks started showing pretty quickly after the applications were processed. By late 1999, the scale and pattern just stood out.
How so?
Telstra's own internal systems, and importantly, the regulators like ASIC, they flagged this unusual cluster of applications. It just looked wrong. Too many applications, despite the variations, seemed to be originating from or connected to a single source. Red flags went up.
And that kind of red flag, involving potentially hundreds of dodgy applications in a major government float, that must have escalated fast.
It did, very fast and very seriously. The matter was quickly deemed serious enough that the Commonwealth Director of Public Prosecutions, the CDPP, decided to initiate criminal proceedings against Sahade.
Straight to criminal charges. What was he actually charged with?
He was charged under Section 29B of the Commonwealth Crimes Act 1914. At that time, this section dealt specifically with the offense of deceiving a Commonwealth authority in this case, the share registry acting for the government by making untrue representations to obtain a benefit, namely, the extra shares.
So the core accusation was fraud, defrauding the allocation process using false names.
That's the essence of it. Using deception to gain an advantage he wasn't entitled to under the rules of the float.
Okay, so this leads to his first major hurdle. A criminal trial in May 2001. This must have been huge pressure.
His first day of reckoning, as the source puts it. He's facing potentially serious penalties, maybe even prison. So his defense strategy was crucial.
What was his approach? Did he deny doing it?
No, he couldn't really deny the actions. He admitted lodging all those applications using the variations in names and addresses. That part wasn't in dispute.
So what did he dispute?
He disputed the mens rea, the criminal intent. He maintained, and his lawyers argued forcefully, that he never intended to act dishonestly. He claimed he genuinely, sincerely believed his actions were technically legal.
Loophole argument.
Exactly. He was arguing he found a clever way through the rules, not that he was breaking them fraudulently. He admitted what he did, but fought tooth and nail against the legal characterization of those actions as a crime involving dishonesty.
And, kind of remarkably, given the blatant deception involved, he was acquitted. May 31st, 2001.
Yes. A really notable outcome at the time. He walked away without a criminal conviction.
How? Why?
The sources suggest it was probably a combination of legal argument and evidentiary doubt. Maybe his defense team successfully argued that the specific wording of the rules, combined with his insistent claim of subjective belief in a loophole, created enough uncertainty.
Enough reasonable doubt for a judge or jury.
Possibly. Enough doubt about whether his actions met the very high criminal standard of proving dishonesty beyond reasonable doubt. It's a high bar.
So, relief for Sahade. Huge relief, surely. He walks free from criminal court. But that wasn't the end of it, was it?
Not by a long shot. While he avoided a criminal record, the facts of what he did were now undeniable and public. And crucially, the NSW Bar Association had already been tipped off about his conduct much earlier.
Well,
Back in November 1999, almost as soon as ASIC started looking into the unusual applications, the Bar Association had launched its own internal inquiry into his fitness to practice way back then.
so they were already investigating him professionally before the criminal trial even concluded.
Yes. And the criminal acquittal. It didn't stop them, not at all.
Why not, if he wasn't guilty criminally?
Because the standards are different. Professional discipline isn't about proving a crime beyond reasonable doubt. It's about whether your conduct, criminal or not, demonstrates you lack the character, the honesty, the integrity to be a lawyer. The Bar Association viewed his behavior, even if acquitted criminally, as a blatant breach of the ethical standards required of a barrister.
So for them, using all those fake names, that whole deceptive scheme, that was enough, regardless of the criminal verdict.
It was deeply concerning. Deception for personal gain, even if cleverly argued away in criminal court, struck at the heart of what they believed a barrister should be.
So even as he's breathing that sigh of relief after the acquittal.
Exactly. As the sources put it, another noose was tightening: professional disciplinary action. The Bar Council, having completed its investigation, filed a formal information that's the official complaint document in these proceedings on November 5, 2003.
Filed where?
In the Administrative Decisions Tribunal, the ADT. The body set up to hear these cases.
And the charge this time?
Professional misconduct, plain and simple.
This was, as the source called it, his second trial.
Absolutely. But the stakes felt different. This wasn't about jail. This was about judging his very identity as a lawyer. Could he continue to practice?
The potential penalties.
Suspension for a period, or the ultimate sanction, being struck off the role, permanently disbarred, forbidden from ever practicing law again.
Which, in that close-knit world of the bar, is seen as
often almost worse than prison, according to peers quoted in the sources. It's professional death. So the case was now officially Counsel of the NSW Bar Association v. Sahade. His entire career, everything he'd worked for, hung in the balance.
Which brings us right to that first judgment day at the bar. The hearing before the Administrative Decisions Tribunal, starting in March 2005. This is where his professional conduct gets put under the microscope formally.
Yes, the disciplinary hearing kicks off before that three-member ADT panel we mentioned: Nader QC, Norton SC, and O'Neill.
The dynamic must have been intense.
You had the Counsel of the NSW Bar Association, represented by their legal team, acting essentially as the prosecution. Their mission, protect the integrity and reputation of the entire profession.
And on the other side,
Marcel Sahade, with his own legal team, fighting to justify his actions and save his legal career. High stakes.
And again, just to be clear, his legal team here at the ADT was specific to this stage.
That's right. The Bar Association had their formidable team, senior counsel instructed by Eakin McCaffrey Cox, pushing hard for disbarment. Sahade was represented by his own team's senior counsel, plus a junior, instructed by Oliveri lawyers. This wasn't his criminal team, nor the QC he'd later bring in for the appeal. This was the team defending him specifically against the professional misconduct charges before the tribunal.
The hearing itself unfolded over 2 days in March 2005. What was the central question they were grappling with?
Well, the basic facts weren't really disputed anymore. The hundreds of applications, the fake names, the scale of the scheme that was all admitted. The absolute core question for the tribunal was, did this admitted behavior, even with the criminal acquittal, demonstrate that Sahade was not a fit and proper person to continue practicing as a barrister?
How did the Bar Association make its case? What picture did they paint?
They painted what the source calls a damning picture. Their core argument was simple. This wasn't a mistake. This was an elaborate, deliberate, calculated scheme of deception. And that kind of behavior showed a fundamental lack of honesty and integrity.
Qualities, they argued, were essential for a lawyer.
Absolutely essential. At the very heart of what it means to be a lawyer, they argued. Someone who would engage in that level of deceit for personal profit simply is not of good fame and character and is not a fit and proper person to remain on the role of barristers. End of story.
Did they address the fact it happened outside his law practice?
Yes, they hit that head on. They argued vigorously that misconduct outside practice is absolutely relevant. The principle, as the source notes, is that conduct occurring otherwise than in connection with the practice of law can be professional misconduct if it reveals a person is dishonorable, untrustworthy, or otherwise unfit for the profession.
Why? What's the connection?
Because lawyers hold a unique position of trust in society. Deceiving anyone, even the government in a share float for personal gain, fundamentally undermines that trust. It corrodes public faith, not just in that individual lawyer, but potentially in the whole profession.
So their demand was unequivocal.
Completely. Remove Sahade's name from the roll. Permanent disbarment. Nothing less would suffice to uphold standards.
That's a heavy case to answer. How did Sahade's defense team, instructed by Oliveri lawyers, approach this? He'd admitted the actions.
It was tricky. They walked what the source describes as a delicate line. Their strategy focused heavily on mitigation and providing context.
Trying to lessen the severity.
Exactly. His counsel argued that Sahade's conduct, while perhaps misguided or ethically clumsy, stemmed from a sincere, if naive, belief that he was just exploiting a technicality or a loophole, not committing deliberate fraud. They really pushed his subjective claim that he lacked dishonest intent.
So arguing ethical blindness rather than inherent dishonesty.
That was the flavor of it, yes. They also pointed to his record, no prior disciplinary issues, competent barrister in his actual work. But perhaps the most powerful weapon in their arsenal was the substantial character evidence they presented.
This is where his colleagues came in.
Massively. In a really striking show of support, Sahade's wife, and get this, 20 colleagues from the Sydney Bar provided evidence for him.
20 fellow barristers.
20. Either testifying in person or submitting sworn affidavits. These were people who worked alongside him, knew him professionally. They attested to his general honesty, expressed belief in his remorse, and spoke about his value as a colleague.
That must have carried some weight.
His defense team certainly thought so. They made a big point that Sahade had proactively disclosed the full details of his wrongdoing, the Telstra scheme, everything to his colleagues on his chambers floor. And despite knowing all that, these colleagues continued to work with him and were now willing to publicly vouch for him.
What was the argument there?
The argument, as the source quotes, was essentially, look, 20 members of the bar, knowing everything, have accepted him as a colleague. Doesn't that speak volumes about his underlying character? Doesn't that suggest they, who understand the standards, still trust him? It was presented as powerful evidence that this was a serious lapse, yes, but maybe not reflective of his fundamental being.
That level of peer support, especially after full disclosure, seems like a very strong card to play.
It was definitely intended to persuade the tribunal that he wasn't irredeemable, that his own peers saw enough good in him. Sahade himself also took the stand.
What was his testimony like?
Initially, he stuck to his guns, maintained the position from the criminal trial, no dishonest intent, genuinely believed it was a loophole. But the tribunal was, well, let's just say, deeply skeptical.
You can see why. The fake names, the scale. It strains credulity a bit, doesn't it?
It does, and the tribunal probed him hard on it, questioned his ethical insight. Did he really not see that using hundreds of variations of names and addresses to get around a clear rule was deceptive?
Was there a key moment?
Yes, the sources describe a dramatic moment during cross-examination. The tribunal pressed him directly. Did he now, looking back, understand that his actions were improper, misleading, deceptive, and wrong?
And his answer?
Initially, he dug in. Remained obstinate, as the source puts it, persisting to the end in his claim of subjective innocence that he thought it was okay at the time.
Wow. Even facing the disciplinary panel, he held that line.
He did. But then, a crucial turning point. There was an overnight adjournment, time to reflect, maybe consult with his lawyers. When the hearing resumed, during his re-examination by his own counsel, he changed his position.
How so?
He finally conceded. He admitted that his actions in the Telstra float were, in fact, misleading, deceptive, and wrong.
A full admission, but it came very late in the day.
Extremely late. And the timing wasn't lost on the tribunal.
How did they react to this 11th-hour concession?
Their reaction, as reported, was scathing. They basically said this 11th-hour acknowledgement, coming only after intense cross-examination and an overnight break, made it quite impossible to accept the sincerity of his original claim that he always thought it was legal.
They thought it was strategic.
They strongly suspected he'd only changed his tune because he realized that in order to show that he is now a fit and proper person, he had to change his position. In other words, they saw it as a calculated move to appear remorseful and save his skin, not a genuine, deeply felt realization of wrongdoing that had occurred earlier.
Ouch. That's a devastating finding on his credibility right there.
It really undermined his whole naive loophole defense and cast serious doubt on his ethical insight at that point in time.
Okay, so the tribunal heard all this, the bar's damning picture, Sahade's delicate line defense, the powerful peer support, his own testimony, including that traumatic late concession. Then they had to make their first decision.
Yes. On July 13th, 2005, the ADT handed down its first reasons. This judgment focused purely on liability. Did his conduct amount to professional misconduct?
And the verdict?
Unsparing is how the source describes it. Marcel Victor Sahade was found guilty of professional misconduct on every count. a total finding against him.
Wow. What specific findings did they make about his character based on that conduct?
They went right to the heart of the statutory test. They explicitly found that he is not of good fame and character. And even more pointedly, they concluded he was not a fit and proper person to remain on the roll at the time he committed the misconduct back in 1999.
Hang on, they didn't just say he committed misconduct. They said that back in 1999, his actions showed he wasn't even fit to be a lawyer then.
Exactly. It was a really striking condemnation. It essentially said his moral compass was so fundamentally off when he did the scheme in 1999 that he shouldn't have been practicing law at that point.
That's huge. How do they justify that finding?
The tribunal used this case to hammer home a core ethical principle. You can't compartmentalize honesty. They stated very clearly that deceitfulness is a character flaw that is not confined to separate compartments of one's life.
So the idea that how you act in your private life reflects on your professional fitness.
Precisely. The sources quote directly from the judgment. Trust is one of the cornerstones. Honest dealing is fundamental to fitness to practice. Even though Sahade's scheme was a personal financial venture, totally outside his legal work, the tribunal saw it as direct evidence about his trustworthiness and integrity as a barrister. Misconduct outside practice can, and in this case did, demonstrate a lack of the essential qualities needed to be a lawyer.
Okay, so a very clear finding of guilt, a harsh assessment of his character at the time of the misconduct, but they didn't actually impose the penalty straight away.
No, they made a specific point of expressly reserving the question of penalty for a later hearing.
Why do that?
It allows for a separate focus. But given how damning the findings were in this first judgment especially, that he wasn't even fit back in 1999, the sources note there was a strong implication that a severe outcome, very possibly striking off, was likely coming. The Bar Association, which had pushed for disbarment all along, must have felt pretty vindicated at this stage.
Okay, so first judgment, guilty, not fit in 1999, penalty deferred. Then there was a pause before the penalty hearing.
Yes, quite a significant delay. About 5 months passed between that liability judgment in July 2005 and the next phase, the penalty hearing. And that delay turned out to be absolutely critical for Sahade.
How so? What happened in those 5 months?
He and his legal team didn't just sit around. They worked intensively, the sources say, to gather fresh evidence of his rehabilitation and character.
Trying to show he'd changed. That he wasn't the same person the tribunal had described in that first judgment.
Exactly. They needed to directly counter the tribunal's scathing assessment of his character, his initial lack of insight, that 11th-hour concession. So when the tribunal reconvened on November 24, 2005, for what was essentially the sentencing hearing,
He came here prepared.
he came armed, as the source puts it, with additional affidavits of contrition and good character. This included updated statements from those colleagues, presumably reinforcing their belief in his genuine remorse and his rehabilitation.
And the whole atmosphere of the hearing was different this time?
Reportedly, yes. Described as one of contrition, a stark contrast to the defensiveness and perceived obstinacy of the first hearing. His legal team, still the senior counsel and junior from Oliveri lawyers, now shifted focus entirely. They implored the tribunal for mercy.
What was their argument now?
They argued that his remorse was now genuine and clearly articulated. They pointed again to the unwavering support from his 20 peers as powerful proof of his underlying good character and his potential for reform. They also highlighted the significant damage he'd already suffered to his reputation, the stress, the huge legal costs. Basically, hadn't he suffered enough, learned his lesson?
So a plea for mercy based on demonstrated change and peer support. How did the Bar Association respond to that?
The Bar's counsel argued passionately against leniency. They stuck to their guns. The objective seriousness of the original misconduct, the deliberate large-scale deception, demanded striking off. Full stop. Their argument was simple. How could a lawyer proven to have committed such a fraud be allowed to remain in practice? They argued that upholding professional standards and protecting public confidence required nothing less than removal from the role.
It sounds like a real tension. The gravity of the past acts versus the possibility of present redemption. What did the tribunal decide?
On February 8, 2006, the tribunal delivered its final penalty decision, formally titled NSW Bar Association v. Sahade, No. 3. And the result, well, it surprised some observers, especially given how harsh the first judgment had sounded. The tribunal refused to strike Sahade off.
Wow. After finding him guilty, finding he wasn't fit in 1999, being skeptical of his initial testimony, they decided not to disbar him. That's a major turnaround. What was their reasoning for showing leniency?
The absolute key factor was the tribunal's assessment of his character and insight as they perceived it at the time of the second hearing. They explicitly stated they were now convinced that by early 2006, Sahade had indeed rehabilitated himself and regained insight.
How could they be so sure given their earlier skepticism?
This is crucial. The panel had the unique advantage of observing his demeanor, his testimony, his reactions across both hearings. They directly contrasted his performance in the first hearing, the defensiveness, the late concession, with what they saw in the second hearing.
And they found him more convincing the second time.
They found him genuinely contrite in that second hearing. As one of the appeal judges later noted, the tribunal was in an advantaged position to gauge his sincerity because they'd seen and heard him directly over time. They formed the view that he had truly learned his lesson and was unlikely to reoffend.
And did the support from his colleagues influence this?
Yes, definitely. The tribunal explicitly stated they weighed the impressive chorus of support from his 20 colleagues and his wife very heavily. They interpreted the strong peer backing as evidence that his misconduct in 1999, while undeniably serious, was perhaps an aberration, a terrible lapse in judgment, rather than reflecting a fundamentally dishonest character.
The fact that fellow barristers, knowing everything, still trusted him, that mattered.
It carried weight, yes. It helped convince the tribunal that he wasn't beyond redemption, that he still possessed qualities worthy of a barrister, despite the serious mistake.
So it was the combination.
Yep.
The tribunal's own assessment of his changed demeanor and sincerity in the second hearing, plus that powerful peer support. That's what tipped the scales away from striking off.
That seems to be the essence of their reasoning.
So what was the actual punishment they imposed instead?
They handed down what the source calls a stern but merciful punishment. It consisted of 3 parts. First, a public reprimand, a formal public censure of his conduct, making the details public record. Second, a $10,000 fine. And third, he was ordered to pay the Bar Association's substantial legal costs for the entire proceedings.
How was this decision received in the legal community?
It definitely caused a stir. The legal world was abuzz, apparently. A major national newspaper, the Australian Financial Review, ran a headline, "Barrister keeps his practice." The sources mentioned that article specifically highlighted the impact of the heartfelt testimonials from his 20 colleagues and his wife in persuading the tribunal.
It sends a pretty complex message, doesn't it?
Nice.
Especially to young lawyers.
It really does. On one hand, you can be found guilty of serious professional misconduct involving dishonesty, be branded unfit at the time of the conduct. But through demonstrating what the tribunal accepts as genuine remorse, showing you've regained ethical insight, and crucially, having strong support from your peers, you might just avoid the ultimate professional penalty. It showed a potential path to redemption exists, even after a very serious fall.
But this still wasn't the absolute end of the legal road, was it?
No, neither side was entirely happy. The Bar Council felt Sahade had gotten off lightly and worried about the precedent it set that serious dishonesty might not lead to striking off. They wanted a harsher outcome.
And Sahade, he kept his practice,
But he still had the formal finding of professional misconduct and the public reprimand hanging over him. He presumably wanted to clear his name further or challenge those findings. So both parties decided to appeal the tribunal's decision.
setting the stage for the final act, the appeal to the NSW Court of Appeal.
Exactly. The ultimate showdown. The Bar Association appealing the penalty, seeking striking off. Sahade cross-appealing, defending the penalty decision, but also potentially challenging the misconduct findings. It all moved to the highest court involved in the case.
The Supreme Court of NSW Court of Appeal, May 7, 2007. Before those 3 eminent justices, Mason P., Santow J.A., and Baston J.A.
The atmosphere must have been incredibly solemn. This wasn't just about one man's career anymore. It was about the Court of Appeal potentially articulating the standards for the entire profession.
And this is where the legal teams got their final upgrade.
Yes, reflecting the gravity. The Bar Council, now the appellant fighting for striking off, brought in that heavy artillery we talked about. Lead counsel, P.R. Garling SC, a future Supreme Court judge. Assisted by C.A. Webster, instructed again by Eakin McCaffrey Cox, a very powerful team showing the bar's unwavering resolve.
They were not giving up on disbarment. And Sahade also brought in a new leader.
He did. Representing Sahade as the respondent, defending the tribunal's decision and cross-appealing, was B.W. Raymond QC, an experienced Queen's counsel, assisted by G. Heathcote, instructed by Oliveri lawyers. And remember, Raymond QC had not been involved at the tribunal level.
Fresh eyes for the final battle.
Fresh eyes, perhaps a different strategy specifically tailored for the appellate court.
Okay, so what were the key arguments of the Bar Association, led by Garling SC, put to the Court of Appeal?
Their main thrust was that the tribunal had made an error of principle. They argued that the sheer gravity of Sahade's dishonest conduct, that deliberate, large-scale deception for profit, simply demanded disbarment, full stop. Subsequent remorse couldn't erase the seriousness of the act itself.
They felt the tribunal got the balance wrong.
Yes, they argued the tribunal gave too much weight to the post-misconduct character evidence, the testimonials, the apparent remorse shown later, and crucially, not enough weight to the objective seriousness of the dishonest scheme itself.
Any procedural points?
They touched on a few, arguing the tribunal wasn't bound by its initial views on penalty and hadn't erred by not listing every affidavit in the first judgment. But the core was the principle. Serious dishonesty demands removal.
And what about that legal point concerning when fitness is assessed? How did the bar use that?
This was critical to their argument for striking off. They argued that while fitness to practice is ultimately assessed at the present time, i.e. the time of the hearing, the conduct itself must be measured against the required standard. Their point was, you don't excuse misconduct just because someone says they've improved since.
So even if reformed by 2006?
Their argument was, his acts in 1999 demonstrated he lacked the essential qualities at that time, and that finding of unfitness based on the conduct itself warranted removal from the role regardless of later repentance. They wanted a clear precedent. Serious dishonesty generally equals striking off. Send a strong message.
Okay, that's the bar's push for a harsher outcome. What was Sahade's strategy, led by Raymond QC, in response and with his own cross-appeal?
His cross-appeal was framed somewhat tactically. His counsel basically indicated, look, if the bar's main appeal fails, if the Court of Appeal decides not to strike him off, then we won't push our own cross-appeal too aggressively.
Priority number one was just keeping his practicing certificate.
Exactly. It was pragmatic. Minimize the risk of rocking the boat if the main threat was averted.
But they did raise some issues to defend the tribunal's leniency.
Yes. They touched on procedural fairness arguments, though didn't push them hard. Their key substantive point related to the interpretation of that old statutory test for misconduct, Section 127(1)(b. The bit about conduct showing someone is not of good fame and character or is not a fit and proper person.
What was their argument about interpreting that section?
They argued against a strict snapshot view, either only looking at the time of conduct or only at the time of hearing. They pushed for the more holistic, forward-looking test that the tribunal seemed to apply in the penalty phase, basically. Considering the entire picture of the past act, yes, but also the present character, the rehabilitation, does this person now pose a risk that requires removal, or can the public be protected adequately with a lesser penalty like the reprimand and fine?
Trying to justify the tribunal's ultimate leniency based on the evidence of change.
Precisely. Though the sources note this was always going to be an uphill battle, as courts tend to view such sections as setting the criteria for evaluating the conduct itself. But it was a crucial point for the Court of Appeal to clarify. How do past conduct and present character interact in these disciplinary decisions?
Okay, so the Court of Appeal heard these powerful arguments from both sides. They had to weigh the objective seriousness of the 1999 scheme against the tribunal's finding of genuine remorse in 2006, interpret the law. What was the final verdict?
The judgment came down on June 19, 2007. Counsel of NSW Bar Association v. Sahade, 2007, NSW CA 145. And the decision was unanimous. All three judges agreed.
Agreed on what?
They dismissed both appeals. The Bar Association's appeal seeking to strike him off was dismissed, and Marcel Sahade's cross-appeal was also dismissed.
So the practical outcome was the tribunal's decision stood.
Exactly. The reprimand, the $10 fine, the costs order,
Yeah.
and crucially, Marcel Sahade remained a barrister.
He wrote the leading judgment.
Justice John Baston, J.A., delivered the main reasons, with President Mason and Justice Santo, J.A., concurring. The core finding was that the ADT had applied the correct legal principles in its two-stage process, and that the final penalty decision was a permissible outcome based on the evidence the tribunal had before it, particularly in that second hearing.
What were the key points the Court of Appeal made in reaching that conclusion?
They systematically addressed the main arguments. First, on the tribunal's two-stage process. No error. They found it was lawful and sensible to deal with liability first, then penalty. And critically, they confirmed the tribunal was not bound by any initial views on penalty. It was entirely free to impose a different, lighter penalty after the second hearing based on the new evidence and its revised assessment of Sahade's character and remorse.
Okay. What about the argument that the tribunal gave too much weight to the character evidence from colleagues?
The Court of Appeal rejected that too. They said the tribunal's failure to list every single affidavit in the first judgment wasn't a material error. And this is where they emphasize that important principle. The tribunal has to form its own independent view of the practitioner's character. It can give whatever weight it thinks appropriate to the opinions of others, like colleagues.
So peer support helps, but it doesn't automatically save you.
Exactly. It's a supplement, not a shield, as the sources put it. The tribunal's own assessment, based on seeing the person, hearing them, judging their sincerity, that's paramount.
And the absolutely critical point about misconducts happening outside legal practice.
The court was emphatic on this. They emphatically agreed with the tribunal. Conduct outside the courtroom can warrant professional discipline. They reinforced the general principle: dishonest conduct, wherever it occurs, reflects on fitness to practice law. Personal and professional integrity are inseparable.
Justice Bastin had strong words on this.
He did. He said the duty of honesty isn't a costume a lawyer puts on for court. Dishonesty, not in connection with practice, can still fundamentally demonstrate unfitness to practice law. No hiding place for private dishonesty.
Okay, no wall between private and professional ethics. What about the timing issue? When is fitness assessed? Past conduct versus present character.
The court gave important guidance here. They rejected a strict interpretation that the statute only looked at fitness at the time of the hearing. They clarified the provision sets criteria for evaluating the conduct. If the conduct itself, whenever it happened, showed a lack of good character or fitness at that time, then it is misconduct.
So you can't just repent later and pretend the misconduct didn't happen.
Correct. The past act stands as evidence of unfitness then. You can't automatically escape a finding of misconduct just by reforming afterwards.
And this is the crucial part for Sahade.
But the court strongly agreed that for the penalty phase, the lawyer's current character, their demonstrated remorse, evidence of rehabilitation, those factors are highly relevant. They are mitigating factors the tribunal must consider when deciding the appropriate consequence.
So it's nuanced. Past conduct grounds the misconduct finding, but present character influences the penalty.
That's a good summary. It's a blend.
How did the Court of Appeal itself view Sahade's actual conduct and his loophole claim? Did they go easy on him?
Absolutely not. They did not sugarcoat his behavior. They agreed in scathing terms with the tribunal that his Telstra scheme was deeply dishonest. Justice Bastin was blunt. They did not accept this claim of subjective honesty. Why? Because the scheme was manifestly deceptive and dishonest, and its very motivation was to deceive.
So the Court of Appeal was convinced he knew it was wrong.
Convinced he knew, or that any reasonable person in his position would have known. They also pointedly noted his troubling lack of insight until that 11th-hour acceptance at the tribunal, which, again, they observed seemed calculated. It was a stark warning. A lawyer who lacks basic ethical discernment or refuses to admit fault when caught is on very thin ice.
Okay, so they agreed his conduct was bad, his initial stance troubling. Why, then, did they ultimately uphold the tribunal's decision not to strike him off?
This boils down to judicial deference. The Court of Appeal acknowledged and respected the tribunal's advantaged position. The tribunal panel had seen Sahade, heard him testify directly, observed his demeanor over both hearings. The appeal court hadn't.
They trusted the tribunal's assessment of his sincerity in the end.
They deferred to it. Justice Santos specifically said the tribunal was well able to reach its favorable conclusion regarding the penalty, because they had that direct first-hand experience of assessing his remorse and rehabilitation. The Court of Appeal found no legal error in the tribunal's decision to be lenient. The tribunal had weighed all the factors, the seriousness of the misconduct against the evidence of reform, contrition, and support, and had stayed within the bounds of its discretion on penalty.
So striking off wasn't automatic, even for dishonesty.
The court signaled it wasn't automatic. Exceptional circumstances, like compelling evidence of genuine reform, credible contrition, strong peer support, could justify a tribunal giving a lawyer a second chance. Sahade's case was essentially treated as falling into that exceptional category.
So the final orders stood. Appeal dismissed. Cross-appeal dismissed.
That's it. And as a final sting for the Bar Association, having lost their appeal, they were ordered to pay Marcel Sahade's legal costs for the appeal. His cross-appeal was dismissed with no costs order, as it was basically moot by then.
A victory for Sahade now. He kept his career, but it sounds like a very qualified victory.
Absolutely. He kept his livelihood, yes. But his reputation was undeniably singed. He was publicly branded by multiple judicial bodies as having engaged in deeply dishonest conduct, even if they ultimately accepted his later contrition. The whole saga, the harsh findings, it's all there in the law, reports a permanent cautionary tale.
So after June 2007, after the Court of Appeal decision, Marcel Sahade is still a barrister, but a changed man, presumably.
You'd have to assume so. He was a free man, still entitled to practice law, but undoubtedly a chastened one. The sources paint a picture of someone who stared into the abyss of disbarment and survived, quite literally, by a hair's breadth.
And that public reprimand wasn't just a slap on the wrist, was it?
Not at all. A public reprimand means the details are published. The misconduct, the court's harsh findings about his dishonesty. It becomes part of the official public record. That's a significant burden for any professional, especially a barrister whose reputation is paramount. But it also serves that public function accountability and a warning to others.
What happened to his practice afterwards? Did he just carry on as normal?
He continued to practice law in New South Wales, yes. But the assumption, as the sources suggest, is that he did so under a much more watchful eye, both formally from the Bar Association and informally from his peers. By all accounts, he kept a deliberately low profile afterwards, avoiding public controversy.
And he mentioned of the Telstra scheme later.
Interestingly, the sources note that years later, publicly available information about his practice, like his chamber's website, maintained a complete silence on the whole Telstra escapade. Suggests the lesson, as the source puts it, had been learned the hard way.
What about the Bar Association? They lost the appeal on penalty.
They lost that final battle, yes, and had to pay costs. But from their perspective, they had still achieved something important. They had drawn a line in the sand. They'd shown they would pursue even a successful barrister for serious ethical breaches outside practice, holding them accountable. It reinforced the principle that standards apply to everyone.
And the case itself, Sahade, its legacy in legal circles.
Huge. It's become a staple in Australian legal ethics courses. Absolutely fundamental. It's cited constantly in textbooks, articles, lectures, whenever the discussion turns to honesty, good fame and character, fitness to practice.
Why is it such a key case?
Because it's such a vivid, real-world illustration of core principles, that your character is your most valuable asset as a lawyer, that dishonesty can destroy it, that it's incredibly hard to rebuild trust once broken. That quote from the tribunal, "Honest dealing is fundamental to fitness to practice," is often directly tied back to Sahade. It put everyone on notice. The courts, the professional bodies, they are vigilant about this.
It really does read like a modern morality play for the legal profession.
It does. It forces you to ask, what does fit and proper actually mean, especially when someone makes a serious mistake? Sahade's outcome shows that while dishonesty is taken incredibly seriously, redemption is possible. But, and it's a big but, it's strictly conditional on genuine change. You need demonstrated remorse, real ethical insight regained, and often, like he had, the strong backing of your peers who believe in that change.
And for every law student, every new barrister starting out today,
they are almost certainly going to encounter this case, and they should. It's a powerful, unforgettable reminder. No clever scheme, no perceived loophole, no quick profit is worth gambling your entire legal career over. Your reputation for honesty, it's priceless. Trying to game any system, even a share float, because you think you're smarter than the rules. Sahade shows how badly that can end.
the implications flowing from the Sahade case are significant, aren't they? They really help solidify some key ethical benchmarks for barristers in Australia.
They really did. The case didn't invent these principles out of thin air, but it powerfully reinforced and clarified them in a very high-profile way. It became a leading judicial example. One of the biggest takeaways is the solidification of a unified ethical standard.
Meaning you can't just switch your ethics on and off depending on whether you're at work.
Exactly that. The case hammered home that there's effectively no separation between your personal conduct and your professional standing when it comes to fundamental honesty and integrity. That duty of honesty, it's indivisible. It applies 247.
Even though Sahade's scheme was purely personal finance, nothing to do with clients.
Didn't matter. The disciplinary bodies, the courts, they treated his deception in the Telstra float with the same seriousness as if he'd lied to a judge or defrauded a client. It underlined that lawyers are expected to uphold the spirit of the law, be honest in all aspects of their lives, not look for tricky ways to exploit rules or deceive others for personal gain, even completely outside their professional role. As the courts found, dishonesty in your personal affairs inevitably casts grave doubt on your fitness to be trusted as an officer of the court.
The case also shed a lot of light on that phrase, good fame and character, a requirement for lawyers.
Yes, it gave it real teeth. It clarified it's not just about not having a criminal record. Sahade was found to lack good fame and character specifically because of his deceptive conduct, even though he was acquitted criminally.
And that striking hypothetical the tribunal used.
That was key, and the Court of Appeal endorsed it. The hypothetical was, even if Sahade genuinely believed his scheme was okay, that very purblind ethical judgment, that inability to see blatant dishonesty for what it was, would itself prove him unfit. And if he knew it was wrong and did it anyway, well, that's just straight up dishonesty, which also proves unfitness. Either way, he fails the test.
So pleading ignorance about basic ethics is no defense.
Not according to Sahade. The lesson is crystal clear. A lawyer must possess sound moral judgment. If you can't distinguish right from wrong in fundamental matters like not using fake identities to cheat a system, you're fundamentally incompatible with the profession. Disciplinary bodies can now point squarely at Sahade to counter claims of ethical ignorance about obvious dishonesty.
You also mentioned the timing, the idea that reforming after the misconduct doesn't wipe the slate clean.
That's right. The case confirmed there's no automatic temporal loophole. You can't commit serious misconduct, then reform, and expect the misconduct finding itself to just disappear. The courts clarified that the statutory test looks at the conduct. If that conduct, when it happened, showed you lacked fitness, then that constitutes misconduct. Full stop.
But, again, the crucial nuance for Sahade.
But the courts also strongly affirmed that genuine remorse, proven rehabilitation, regained ethical insight, all that is highly relevant at the penalty stage. While you can't erase the finding of misconduct by reforming, showing you've truly changed can persuade a tribunal to show mercy and impose a lesser penalty.
So it's a balanced message.
It is. Character is judged over time. Past deeds matter for the misconduct finding. Present attitude and demonstrated change heavily influence the consequence. Defiance or ongoing lack of insight. Very risky, likely leads to striking off. Credible remorse and proven improvement can mitigate the penalty, though not absolve the act.
What about the role of all that character evidence from his colleagues? How did the case clarify its importance?
It clarified that while character evidence is influential, it's not decisive. The Court of Appeal was clear. The tribunal makes its own independent judgment about character. It's not bound by what colleagues say. Peer support is valuable, it can be persuasive, especially on penalty, as it clearly was for Sahade. But it's a supplement, not a shield. You can't just rely on being popular to excuse serious wrongdoing if the tribunal itself isn't convinced you've genuinely changed.
And running through absolutely everything is the paramount importance of
honesty. Above all else, Sahade is probably the leading modern case reinforcing that honesty is the absolute bedrock of fitness to practice. That ADT quote bears repeating. Trust is one of the cornerstones. Honest dealing is fundamental. It embodies the idea that a dishonest lawyer is a contradiction in terms.
The Court of Appeal's harsh description of his scheme serves as a deterrent.
A powerful one. And the fact Sahade only survived disbarment by the skin of his teeth sends a clear message. Others engaging in similar conduct might not be so lucky. Gambling with your integrity truly is gambling with your career.
And underlying all these specific legal and ethical points is the broader concern for
public confidence. That's the ultimate driver. Sahade's scheme, deceiving a public authority and a huge national share float, had the clear potential to damage public trust in lawyers and the profession. Pursuing the case, making the findings public, even the eventual penalty, it was all aimed, in part, at reassuring the community that lawyers are held accountable, that standards are enforced. It reinforces law as a profession, not just a business, where practitioners model respect for the law, not exploit it. It puts lawyers on notice. Even your private get-rich-quick schemes are under scrutiny if they cross fundamental ethical lines.
Were there also some takeaways about the disciplinary process itself, procedural points?
Just briefly, yes. The case validated the common practice of having a split hearing, guilt first, then penalty, found it lawful and sensible, allowing the respondent lawyer to focus fully on mitigation evidence after a finding of misconduct. It also reinforced the idea that while appeals involve a rehearing, appellate courts generally defer to the first instance tribunal's assessment of facts, especially regarding witness credibility and character assessment based on seeing the person directly.
Okay, to really grasp the significance of Sahade, it's useful to place it alongside other major barrister misconduct cases in Australia. How does it stack up against other cautionary tales?
That's a great way to see the patterns. Comparing Sahade helps highlight what makes certain conduct so serious. A classic comparison, especially for financial dishonesty outside practice, is NSW Bar Association v. Cummins.
Cummins, he was the QC who didn't pay tax for decades, right?
That's the one. John Cummins, QC, struck off in 2001 for failing to lodge tax returns or pay income tax for something like 38 years, a staggering period of deliberate noncompliance.
And he was struck off. Why was his outcome different from Sahade, who also engaged in financial dishonesty against the Commonwealth?
Several key differences: the sheer duration and persistence of Cummins' wrongdoing decades versus Sahade's few weeks of a scheme. The court saw Cummins' conduct as a sustained, ingrained pattern of deliberate deception. Also, arguably, the evidence of genuine, timely remorse and insight was less convincing in Cummins' case compared to what the tribunal eventually accepted from Sahade in his second hearing. Cummins is the stark warning. Serious, persistent financial dishonesty, even if unrelated to clients, is almost certainly career-ending.
What about older cases like Ziems v. Prothonometry from the 1950s? That involved the death, which sounds much worse.
Ziems. Louis Ziems, a barrister convicted of drunken vehicular manslaughter, served prison time, initially struck off, but the High Court on appeal in 1957 actually overturned the disbarment and let him be reinstated.
That seems astonishing today. Manslaughter versus financial scheme, yet the financial schemer almost got struck off. The manslaughter got reinstated.
It does seem astonishing, and Ziems is widely seen as a historical outlier, reflecting very different attitudes back then. The High Court found unusual mitigating factors, maybe concussion clouding judgment, and crucially distinguished between the crime itself and fitness as a lawyer. Their reasoning, controversial now, was that while manslaughter is terrible, it wasn't inherently dishonest or directly related to his practice duties. It was seen as an isolated, reckless act, not necessarily proving permanent unfitness for legal practice.
How does that contrast help understand Sahade?
It highlights the profession's intense focus on honesty. Ziems caused death, undeniably worse harm. But his act wasn't seen as fundamentally dishonest in the way Sahade's deliberate scheme was. The legal profession views dishonesty, deception, lack of candor as striking right at the core requirements of being a lawyer in a way that even some other serious crimes might not. Attitudes are much stricter now. Ziems would almost certainly be struck off today. But the contrast shows why Sahade's dishonesty was treated so seriously, even though it was just about money.
Are there cases involving dishonesty specifically around getting into the profession?
Yes. NSW Bar Association v. Samosi, 2001, is a key example. Lawrence Samosi was struck off years after admission when it came out he'd falsified his university results before he applied to be a lawyer, lied about failing exams.
So, deception right at the entry gate.
Exactly. The court found this deliberate lie, even years earlier, meant he wasn't of good fame and character from the very start ab initio. It showed a fundamental lack of integrity required even to become a lawyer. It reinforces that there's no time limit on character flaws. Dishonesty can catch up with you. Compared to Sahade's misconduct after admission, Samosi's lie went to the heart of his qualification and arguably involved misleading the admitting court itself. Both involve deception for personal gain, but dishonesty about qualifications is seen as particularly grave.
And then there are cases where lawyers commit serious crimes directly linked to their work.
Right. Things like perverting the course of justice, helping clients smuggle drugs, cases like R.V. Murphy or Barristers Board v. Young. When a lawyer is convicted of a serious crime like that, especially if it involves abusing their position or undermining the justice system, disbarment is virtually guaranteed. Sahade's crucial difference was avoiding that criminal conviction, which allowed the disciplinary process to focus purely on the ethical standards.
A more recent huge scandal is the Lawyer X case, Nicola Gabo.
Yes, arguably one of the worst breaches of legal ethics in Australian history. Gabo, a criminal defense barrister, secretly informing on her own clients to the police, a catastrophic betrayal of confidentiality and loyalty.
That feels like a fundamentally different category of wrongdoing than Sahade's scheme.
Absolutely. Gabo's actions directly harmed her clients, corrupted trials, undermined the entire justice system. It led to a royal commission. While Sahade's actions were selfish and dishonest, they didn't involve that profound betrayal of client trust or direct subversion of the judicial process. The universal condemnation of Gabo highlights the ultimate moral sins. For a lawyer, breaches of duty to client and court are seen as even more fundamentally damaging than personal financial dishonesty. Her case puts Sahade's misconduct into perspective on a spectrum.
What about more contemporary issues like workplace behavior?
The recent case involving Charles Water Street 2024 is relevant here. A high-profile barrister found guilty of professional misconduct for sexually harassing junior staff in his chambers. The penalty imposed was suspension for a year, not striking off.
Interesting. A suspension like Sahade avoiding striking off suggests a path back.
It does. It shows the definition of misconduct is evolving to include things like workplace harassment. And importantly, it shows that even for serious misconduct in this area, the system might allow for a return to practice after a period, presumably contingent on rehabilitation and addressing the behavior. It aligns with Sahade in the sense of avoiding permanent removal, but the context and nature of the misconduct are obviously very different.
Looking across all these examples, Cummins, Ziems, Samosi, Gabo, Water Street, and Sahade, what are the big consistent takeaways, especially for someone thinking of joining the bar?
Several crucial lessons echo through all these cases. First, the absolute gravity of dishonesty. Cases involving lies, deception, lack of candor, they almost always trigger the harshest responses. Dishonesty is seen as fundamentally incompatible with being a lawyer. Second, mitigation has limits. While remorse, rehabilitation context can lead to outcomes less severe than striking off, like for Sahade, maybe Water Street, it's highly fact-specific. Standards are arguably stricter now than in Ziems' time. Sahade's survival was remarkable, showing redemption is possible, but only with compelling evidence of genuine change, and often only if the misconduct is seen as a lapse, not ingrained. It's not a get-out-of-jail-free card. Third, it always comes back to the public interest. Protecting the public, maintaining confidence in the profession that's the ultimate driver. Does letting this person practice pose a risk? Does it damage the profession's standing? For Sahade, the courts ultimately felt the reprimand and fine were sufficient given his turnaround. For Cummins or Gabo, only permanent removal would do.
And the message for aspiring barristers.
These cases are not just interesting stories, they are essential warnings. They show that legal brilliance isn't enough. Ambition isn't enough. Your character, your integrity is paramount. The willingness and ability to obey the law, honestly, is fundamental. If you think you can cut corners, find deceptive loopholes, or act like rules don't apply to you, these cases show the fall is swift and brutal. They define the ethical boundaries. You're expected not just to meet them, but to be an exemplar of integrity.
So the story of Marcel Sahade, when you boil it all down, it's this powerful, almost stark reminder for anyone in law or thinking about it. Integrity isn't just for the courtroom, is it?
No, it's a 247 obligation. His audacious scheme, totally outside his practice, proved that dishonesty anywhere can absolutely torpedo your legal career.
You show that line between your private conduct and your professional fitness. Well, it's maybe thinner and brighter than people think.
Much thinner. Your character is assessed as a whole. The profession, the courts, they expect consistency.
And while the system, in his very specific case, did ultimately find room for mercy, convinced by what the tribunal perceived as real remorse, genuine change, and that remarkable support from his peers.
That mercy came with conditions. The public reprimand, the fine, and those scathing judicial findings about his dishonesty manifestly deceptive, motivation was to deceive. Those are permanent scars. They're forever in the public record in the law reports. He survived, yes, but the cautionary tale is indelible.
So for every law student, every junior barrister navigating the pressures and temptations, the name Sahade is basically shorthand now, isn't it?
It really is. Shorthand for the dangers of misconduct, for the potentially catastrophic consequences of dishonesty, and for the absolutely priceless value of guarding your reputation for integrity.
Maybe the deepest lesson here isn't just, don't lie, don't cheat. It's something more fundamental.
I think so. It's not just about fearing the consequences. It's about cultivating a genuine ethical core, truly understanding why honesty matters, why integrity is non-negotiable, not just memorizing the rules. And then if you do falter, as humans sometimes do, Sahade's story suggests that the only path back, maybe, is facing it squarely, admitting the wrong without reservation, and actively, demonstrably proving you've changed and regained that insight. It's a tough path.
It really leaves you thinking, doesn't it?
Yeah.
What does fit and proper truly mean when faced with serious human error, but also evidence of genuine, hard-won change?
A question the profession grapples with constantly, and Sahade's case is a key part of that ongoing conversation.